escalates, that's on behalf of the people.
When you're our assistant public defender, what type of self on behalf of Mr. Covington? Yes, sir.
Morning, Your Honor. Sean Covington.
Thank you. What are we doing?
We would have to go here on this matter or discovery.
And Your Honor, I wish the attorney would like to respond.
Go ahead.
Your Honor, at this time, the people will be requesting the defendant's bond be modified to the original 100,000 cash surety passed by arraignment. This defendant failed to appear in 2023 for this case and exam and proper witness. He was also out on probation for ad stock and picked up 2 felony charges, I believe. And I believe in this case, he was released on May 7th, and it showed on, actually still has a warrant for a BOP, other non-support warrants. And the people believe that in this case, the bond will be appropriate at $100,000 given the serious nature and concern for the victim's safety. In this case, the victim and defendant come in, the defendant was at the residence with their daughter. The victim picked her up. The argument began while they were arguing. The defendant pulled the gun from his waist, cocked the gun as if to load around, pointed it at the victim and also at their car that their child was in. The victim was in fear for her life and he struck her with the gun 3 times and then fled. When the officers talked to the victim, she had noticeable swelling above her left temple, a cut above her ear, and blood on her shirt. We were also concerned given the defendant's past history of assaultive and domestic violence charges, as well as dismissed domestic record. Mr. Levy asking that the bond be set at $100,000.
Response. How did he come into custody?
Your Honor, I was in Detroit.
Okay. How'd you get into custody? Did you walk in or were you picked up?
I was picked up in Detroit.
Mr. Allen.
A case out there. And then I handled all the case. I came out here. I got discharged off of conviction. I had to stay in Washington County for about 7 years. So when this came in,
He was picked up originally, but I think that this second attempt at bond increase, the second bite of the apple, he was released. He's coming to court today. He's ready to.
But hold it. While he was out, basically absconding on this case, my understanding is he picked up other cases?
That's the people's understanding. While he was on probation for aggravated stalking, the judge slaves court.
Those are support cases, if I'm correct. Good.
Or it might be on 14. I know he had a BOP hearing on 5/2, the judge said.
The initial was a failure to appear when we were before the thing. I did that arraignment for him. And there were 2 months of time where he was in the hospital, if I recall, and he suffered some burns as the court made clear.
Hold on a second. Because back, just looking for a date on this, I don't know that the defendant just didn't come into court. He was incarcerated in Wayne County, January of this year. And then proceeded to send us information for a plea by mail. Requesting a trial date review a bond with a request for dismissal due to the hearsay clause and Washtenaw County has no jurisdiction over me. Because he's a permanent resident of Wayne County. Yeah, go ahead.
At the arraignment, we were going back and forth with our magistrate Pink and I, and she said, I won't quote her exactly, but the summary of it was, let him out on bond because some of it was confusion. He should be holding himself to the same standard as an attorney, but this was kind of an attempt at self-representation that went horribly wrong. And so as you can see, he's here now with an attorney. He's coming into court to address these charges, to address everything that's happening. He's not a flight risk judge. He's here now, so I would say that
He's not a flight risk? Where was he?
he was in the hospital for 2 months, Your Honor.
When?
The court date in question, I remember it was April 4th. And he was in the hospital at that time.
Your Assistant Prosecuting Attorney Morgan Barroso and other people, looking back at our notes, what we see is that this is a 2022 case. He was set for exam pro se on March 7th. The victim was present, willing, and cooperative. The defendant appeared on Zoom. The court, they tried to proceed with the exam at that date, but the defendant had insurmountable technical difficulties, so it was adjourned out to April 4th. And on April 4th, the defendant didn't show up.
Did not
show up. He failed to appear, and he was put in bench warrant status. After that, on the 11th of April 11th of 2024, over a year later, he's in custody in Wayne County and mails in the misdemeanor plea by mail to the court.
correct.
So he's in bench warrant status for over a year. And obviously there's something else, other context with law enforcement going on because he's in custody in Wayne County during that time while in bench warrant status. I'm sympathetic to him being in the hospital for a couple of months in there, but that doesn't explain the other 10 months plus where he was in bench warrant status and failed to turn himself in. At this point, I think that there's an issue with his bond being where it is and with him being out of custody, at least without having a GPS.
Well, but he didn't appear for a preliminary examination.
Correct.
This lawyer informed me that I had a case in Washtenaw County for a different reason. So at that same time, my lawyer told me to call down here, get on video camera. I was doing everything on video camera from the hospital. I saw it one time on the camera. So
It wasn't my preliminary examination.
yes, examination because I was in the hospital, so technical reason for the computer stuff.
Oh, no. So then, after you missed a preliminary examination, what took you so long to turn yourself in? Well, you didn't turn yourself in, you got picked up.
It's like Magistrate Garwood says all the time. I tell this to my clients. I said, look, if your cell phone bill goes out, if cable goes out, you're going to pick up the phone, you're going to call that and get that resolved immediately. And
I don't know if quoting Magistrate Garwood is convincing to me.
but what I'm saying is, Your Honor, I explained this to him. He wasn't represented before. He didn't understand. He tried to represent himself.
Oh, I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months. And I don't know why a bond was set when we finally get to him in the amount that it's set at. In my opinion, that's a clear abuse of discretion. He didn't appear for 2 court proceedings. Well, appeared at 1. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
It was a obstruction of justice, and I took care of that case. I came back here, I got dismissed off of probation. Judge Smith, but bear with me, because I lost my lyrics, I lost my whole day. So I had to give my body to them. And then I'll promise her that I'll come back and take care of this, because I need to do this behind. I lost my whole day, as you can see. So I have to talk.
I understand that. I'm glad it's worked for you. All I'm saying is you haven't appeared at these proceedings. You didn't turn yourself in. You got picked up. And that's the only reason that you're here. Otherwise, we would probably not be seeing you. As I've said, I think it's an abuse of discretion that this bond was set as it was. Your bond now will be $50,000 cash surety, defendant's remanded. Oh. Did I send it to you? I did not. I'll set the probable cause out. I'll just set it out since I took him into custody. I'll set it out next week, May 16th, 2024, 9 a.m. Court does call the case People versus Yusuf Cyrus. Who is this? Who? Oh, here. Hang on. Bring it back. Yeah. Step back a second first. I'm sorry. Court does call the case of People versus Mohammed Farah.
People.
Good morning, Your Honor. On behalf of Mr. Farah, now to my
Okay, what are we doing?
Thank you. Look at the man for preliminary examination.
Discovery's complete.
Yes. Do it all with you.
Of course you would. Discovery is complete. People had their witnesses available the 21st. Preliminary examination will be set May 21st, 2024, 9 a.m. That is before Judge Valvo. As to bond.
Thank you. Regarding bond, Mr. Farah does have another matter. Your English bond is $2,625. He tells me that he intends that they told that he's granted a PR on this case.
Did he post it?
No, he doesn't intend to. If the court is inclined to grant him a personal bond on this matter, he does have safety.
So we get into a chicken or the egg, because I'm not moving it if he's got another bond.
And other cases of CCW use.
Thank you.
That's correct, Your Honor. Would this be more appropriate to raise that preliminary examination after he posts the bond on the other matters?
I would think so. Judge Valvo would be more than happy to hear it.
Thank you.
At this time, motion for bond reduction is denied. Bond will continue. Thank you. Court recalls the case People versus Yusuf Cyrus.
I'm taking the record.
Thank you.
Your Honor, we're just asking for a 3-week adjournment to submit mitigation information to that here at the row, so consider it.
May 30th, 2024, 9 a.m. without objection. Bond continued. Thank you. Court calls the case People versus David Davis.
Good afternoon for the people.
Good morning, Your Honor. Judge Overwater, this is public defender on behalf of Mr. Davis. Approaching. Mr. Davis, you should state your name for the record. Mr. Davis.
What are we doing?
We worked out a plea agreement. Plea form was sent to the court last night.
Plea form that indicates he's going to plead to attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 are dismissed. That's the court's entire understanding of the agreement.
Correct.
Yes, sir.
7-1.
You sound too much about testimony about the truth and all that's the truth God.
Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $2,000, I think it's actually $1,000 fine plus court cost. You understand that? All right. You understand also, sir, that that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in 14A2 District Court. All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead?
Yes.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. And because you believe that you are indeed guilty of this offense? On the date of February 29, 2024, at the location of Buckingham Drive near Hamlet Drive, Superior Township, Washtenaw County, State of Michigan, did you come into contact with Washtenaw County Sheriff's deputies? What happened?
I was in the garage, I told me to come out of the garage, and I was waiting there.
How'd that work?
It worked.
Yeah. You kind of came out of the garage. Yeah. You have no dispute they were giving you a lawful command to come out of the garage, do you?
I
You're not disputing that it was a lawful command they were giving you to come out of the garage. You just didn't come out. Well, not. But you eventually came out. Yeah. Counsel, I complied with the court rule. Would it be proper to accept this defendant's plea?
Defense is satisfied, thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
July 9th at 10 a.m. before the bar.
when?
July 9th.
July 9th, 2024. What time? Doesn't matter.
10 a.m.
10 a.m. Before Judge Barr. Bond continue.
Thank you, Your Honor.
60 days. It's 2 months. Okay? Emily, I'm just counting. I don't know.
Yes.
Court calls case People versus Wayne Franklin.
Attorney Martin LaRose on behalf of the people.
Your name, sir. Thank you. What are we doing?
Your Honor, that's set this matter for preliminary examination. I would ask the court also to consider a bond.
Discovery complete on both cases. People have their witnesses available the 21st.
We'll go back here.
Preliminary examination will be set in person, May 21st, 2024, 9 a.m. before Judge Valvo. That's the bond.
Your Honor, it's my understanding that the complaining witness in this matter is likely left the state. She does not reside with my client. He has his own place that he'd be staying at. My client has 2 jobs. He works for a cleaning service called Arrow Cleaning, where he works nights. He also works at AF John, where he's a property manager for various strip malls. He indicated he resides on Alpine Drive. His mother also lives locally. He has her support. I'd ask the court to consider releasing Mr. Franklin. Personal recognizance bonds, you have to comply with the tele requirements the court felt if they were necessary. The allegations in these cases are not particularly aggravating. There has been, to my knowledge, no indication that he's had any contact with complaining witness since since he's been incarcerated. So I would ask if the court would be willing to consider his release today. He has reported to me that he is the only provider for his family. His wife does not work, and if he continues to be incarcerated, he will lose his full jobs.
Respond.
I first want to note out the gate that he has bond denied at 15th District Court, and that is not up until May 15th. But on the attempted home invasion case between April 7th and April 11th, the defendant assaulted and stole the victim's iPhone. The defendant was released on a PR bond on April 19th. It was prohibited from having contact with the victim or going to the residence. On April 24th, he told the victim that he was allowed to have visitation with the children and came to the residence. The victim, after that, then called the court and learned that what the defendant told her was a lie. The defendant has repeatedly harassed and texted and called the victim, resulting in aggravated stalking charges in the case 24-5094. In the attempted home invasion, he violated the no contact order, founded on the defendant's words, or founded on the victim's words, causing damage to the security. And it was so loud that it caused neighbors to take notice and filmed the defendant leaving the scene. I also want to note that as far as his contact with the victim, he did text her, he contacted her multiple times, resulting in aggravated stalking charges, but one of note which gave us concern is on April 26th, saying, I don't know if I can ever forgive you. God is going to really have to help me through this time. He violated a no contact order by the victim about what he was allowed to do and appeared at her residence in violation of no contact. So it wasn't even just virtual or verbal violations. At this point, I would object. I also want to note that we have requested $100,000 on each of these files. On the attempted home invasion, we were only given a $5,000 bond, and on the aggravated stalking, we were only given a $15,000 bond. I'm not asking for an increase today, but I do think any reduction in those already small nominal bonds would be inappropriate at this time.
The text message that was cited by the state is the only alleged contact that he had that makes up the stalking that's a violation of any kind of bond condition. As far as the home invasion is concerned, the only allegation that suggests that he was even involved is the statement of the complaining witness. The alleged damage to the door, according to the report, indicates that the deadbolt was not broken, but the chain was. So the only way that he could have done that would have been to bend the door so far in that it broke the chain, but the deadbolt held. There's no damage to the door, which doesn't actually make any sense.
Motion for bond reduction denied.
Thank you.